Hi there. I'm Dan Daniels, a partner in Wigan and Dana. Welcome to this mini podcast on estate tax planning for married couples. The primary tax we worry about is the federal estate tax. This is a 40% tax that applies to everything you own when you die. There are two main exemptions from the tax. The first is the unlimited marital deduction. That's the ability each of us has to leave unlimited amounts to our spouse at death without the imposition of any federal estate tax. But the marital deduction merely defers tax because anything I leave to my spouse will ultimately be taxed in her estate when she later dies. The only real forgiveness mechanism from the tax is the applicable exclusion amount. That's the ability each of us has to leave approximately $11 million to anybody in the world without the imposition of federal estate tax. I say approximately $11 million because that amount is indexed for inflation each year. Connecticut also has its own estate tax, which applies at a 12% rate. Connecticut does recognize an unlimited marital deduction, and Connecticut has an exemption from its tax that in 2019 is $3.6 million. The goal of good federal estate tax planning for a married couple is to ensure that they get to use two $11 million exclusion amounts instead of only one. And I think the best way to understand that is through a couple of hypotheticals. In hypothetical number one, we have husband, and he has an estate of exactly $22 million. And he has a simple will that says he leaves everything to his wife, and the wife has a simple will saying she leaves everything to the couple's children. So what's the tax result? Well, husband dies, he has $22 million, and it passes to his wife. There's no tax because of the unlimited marital deduction. But now what happens at wife's later death? She has that $22 million in her estate. She can shelter the first $11 million, her applicable exclusion amount, from the tax, but the remainder of her estate, the other $11 million, is taxed at 40%. So there's an over $4 million federal estate tax to pay before the children get their inheritance, leaving them with only roughly $18 million instead of $22 million. That could have been avoided. Hypothetical number two shows us how our married couple could have avoided that unnecessary $4 million federal estate tax. In this case, husband still has $22 million and he still dies first. But instead of leaving everything to his wife as he did in hypothetical number one, he breaks his estate up into two shares. Share number one is an amount equal to husband's applicable exclusion amount of $11 million. Instead of that passing to the wife, it passes to a trust called an estate tax sheltered trust. The wife is given a lot of rights over that trust, but just short of enough rights to be called the owner of it for tax purposes. The rest of the estate, which in this example happens to be another $11 million, passes outright to the wife. Let's stop there. What is the tax result? Husband has died, wife is still alive. Well, we know that the $11 million that passed outright to the wife isn't subject to a federal estate tax because of the unlimited marital deduction. What about the other $11 million that passes to the estate tax sheltered trust? Well, that's not subject to tax either because it's sheltered by husband's applicable exclusion amount. So there's zero federal estate tax to pay at husband's death, just like the simple plan. Where this more sophisticated plan changes things is when the wife later dies. Her estate can only be taxed on what she owns. Does she own the estate tax sheltered trust? No, not if it's been designed correctly. So that passes with zero federal estate tax to the children. What about the other $11 million that the wife inherited outright from her husband? That is included in her estate. She does own it, but it's not subject to tax because it's sheltered by the use of wife's $11 million applicable exclusion amount. And now for the fine print. There are a number of important additional considerations we need to think about. What about state estate taxes? At the beginning of the presentation, I told you that Connecticut doesn't recognize an $11 million exemption from its tax. It only recognizes a $3.6 million exemption. So if we try to put $11 million into an estate tax sheltered trust at husband's death in my hypothetical, the feds will say that that's got zero tax on it at husband's death, but Connecticut's only going to recognize the first $3.6 million as exempt from tax. There'll be a Connecticut tax on the difference between those two numbers. Planning can be done to mitigate that result, and it's something you should certainly talk with your Wiggin and Dana attorney about in constructing your estate plan. You may also have heard about portability of exemptions. This is a way of utilizing both spouses' applicable exclusion amounts without the estate tax sheltered trust. Essentially what happens is, when the husband in my hypothetical died, the executor of his estate could simply check a box saying, I'm going to let my wife use my exemption at her later death. And portability can be the right choice for many couples, but it may not be the right choice. And you want to build in flexibility in your plan to allow the surviving spouse to make that decision at the time when she knows all the facts on the ground. Again, talk with your Wiggin and Dana attorney about including flexibility in the plan to make that happen. So that's our whirlwind tour through tax planning for married couples. If you have more questions, the contact information for your Wiggin and Dana lawyer is on the next slide.